one. Okay, today we're very fortunate to be able to speak to two legal minds, and I'm going to ask them to introduce themselves. So Roland, why don't you start?
Okay, my name is Roland Malivert Jr. Esquire. I'm a personal injury attorney based out of South Florida, currently in Miami, Florida. Had plenty of personal injury cases in my career, had a few dog bite cases. So I just wanted to give my perspective from my side as a plaintiff's attorney who would bring a lawsuit against a pet owner or trainer.
Okay.
Okay, my name is Dushawn Johnson, Esquire. I'm on the opposite end of the spectrum. I fight with guys like Roland. I'm on the defense side, so I'm here more so as moral support, and also I'm also a dog man. So I'm one of the few attorneys that's probably dabbled in both worlds of being familiar with dogs and protection training, also defending cases. I mainly work for governmental entities, so most of my work deals with police dogs. But Roland is definitely the expert on plaintiff work, and I'm just kind of here to offer a little bit more insight from the other side.
Okay, so let me start off. I am a personal protection dog trainer, not a lawyer. I'm not a sport or police dog trainer. I train obedience and personal protection. I believe personal protection is the only moral and legal reason for a dog to bite a human being. My personal space universally is 1.5 to 4 feet from my body, my personal dwelling, and my car. Am I correct?
Yes, you'd be correct there. The reason being is, you want a limited scope. In the law, usually you want to limit the scope of what is legal. In your framework there, what your personal space is, and I would also include anything that you're holding on to attached to you, whether it be a handbag, a wallet, something in your hand would be included in your personal space as well.
Sean, did you want to come in there?
I don't think there's much to add to that. I think Roland's pretty much spot on with that. I think that's a large reason why. And again, most of the law that I'm going to speak into is Florida law. But as far as a person that owns a personal protection dog, that's why it's titled personal protection dog. A lot of people teach their dogs to do send outs and stuff like that. And that's not really the way to go, because you cannot, as a owner of a personal protection dog, send your dog on a send out. That's your police dogs.
Yes.
You have a personal protection dog as a civilian. You don't have a police dog. So doing things like send outs are always going to give you trouble in terms of liability for a bite, because at that point, there is no threat to your person or your immediate property.
Yes, I have long taught my clients that defense is predicated on proximity. So a person 50 feet away, even with a lethal weapon, is not as dangerous as a person 5 feet away with a machete or a baseball bat. Am I correct in that?
Absolutely.
Okay.
Definitely. I think that it's very important to understand what areas are considered to be a threat to you as a human being, and what areas your dog, the scope of how far your dog can go when it is an attacker and an aggressor versus a defender.
Yes. I also tell my people that just because somebody makes you mad as talking about your mother or something like that is not a moral or legal reason to deploy an animal to destroy a human being. That it has to be to protect you from their illegal assault. So let me go to attack versus protection. And Sean, you did speak on that as far as police tactic and civilian. As I know, police have what's called qualified immunity. And I wish that one of you or both would speak to that phrase, qualified immunity, so that our people can realize that police have disqualified immunity versus there's no qualified immunity for a normal civilian. Can you please elaborate?
I don't know if you want me to tackle that, Roland, since that's my area.
Yeah, go ahead.
You want me to jump on that one?
Yeah.
Okay, so there's a thing called sovereign immunity, which is 768.28, and that applies to governmental entities. So governmental entities are immune from a lot of the law. They're not immune from intentional torts or certain areas of negligence you can hold the city liable for. But things like dog bites, you cannot sue the officer individually for that. You have to sue the municipality, unless the officer is acting outside the scope of his duties as a police officer. So sometimes you see a person will sue a police dog, sue someone that is a police officer. Hold on one second. Someone will sue a police officer for deploying a police dog. In that case, the governmental entity takes over and you cannot sue the police officer individually. Now, if the police officer has the dog in his personal ownership and deploys the dog because he's mad at you, then you can sue the police officer. As a civilian, you don't have any immunity from your dog biting anybody. Florida's a strict liability state. So if your dog bites someone, unless it's under a couple narrow circumstances, as a police officer, as a civilian, you're going to be liable for that bite.
Okay, Roland, please step in.
So as Sean was mentioning there with the qualified immunity, what he mentioned the phrase intentional tort. From my perspective, if a dog is put on what you call the send out and you deploy it to attack someone who's 25, 50 feet away from you, we would pretty much categorize that as an intentional tort. In Florida, it's a strict liability statute that says that all you have to prove in order to hold the owner liable is that you were bitten by the dog and that you were lawfully in the place that the bite occurred. So that could be any public place, or if you're on private property that you were invited there, you were legally there, you weren't trespassing. Those two are the only things you have to prove. Not even negligence is a mitigating factor or an aggravating factor in this. If the dog bites you and you're legally supposed to be there, you will be held liable for that.
Very good. So now my next question is, when is a dog trainer liable?
So I'm going to jump on this one. My advice to any dog trainer, when you return the animal to the owner, you have to be very, very clear on what this animal is capable of, how this animal should be treated, how this animal should be brought out into public, not as some attack dog, but as your personal protection in your limited scope. If there is a perceived threat, then you can have this mode of protection. Any other circumstances we mentioned, especially in Florida, is a strict liability. If you deploy this dog in a reckless manner, above negligence, I, as an attorney, may look to, okay, were you properly informed on what this dog is capable of? You recklessly set this dog out, you negligently set this dog out. Are you aware of how dangerous this dog can be to the general public if you're not careful? At that point, I'm going up the chain and saying, who trained this dog?
Yes.
I'm looking at who trained the dog. If the dog trainer is overstating his qualifications, and isn't capable of properly training this animal to return to a untrained individual who owns a dog on a daily basis, then they could be held as negligent and culpable for the injuries of the person who was bitten.
So, you know, I always,
I would say,
okay, I'm sorry. Go ahead, Sean.
I was just going to say that I agree 100% with what Roland is saying. I actually had a question for Roland. I have my own thoughts on this, but if a person has a personal protection dog and the owner is not qualified, gives them an unstable dog, what are your theories on negligence as it relates to even starting the process with an unstable dog?
Okay, if the owner's unqualified or the trainer's unqualified?
If the owner and the dog are unqualified, if the dog is an unstable dog, a dog that the trainer should know this dog has no business doing personal protection.
Okay, in that instance, it is the trainer's responsibility to, at the onset and the intake of this animal and the owner, ask the appropriate questions to find out if this dog is part of the one bite statute, if they've already attacked or aggressively approached someone before. Are they reported and registered with their local authorities as a dangerous or vicious animal? It's the trainer's responsibility to ask these important questions to know what type of animal they're dealing with at the onset. Then it's up to the trainer's professional training themselves to understand, is this a dog that's fit for this purpose? If not, they have to inform the owner of the risks of having this animal and the fact that you are not going to take the risk on yourself by training this animal and sort of guaranteeing that they won't act and display this behavior again. There's certain things that you cannot guarantee at all.
That's right.
And you should not guarantee. At that point, you hold yourself and you put yourself in the shoes of the liable party for having this animal out in the public.
So this very interesting about this, in our state, animal control gives the dog a one bite before he is classified as a dangerous dog. So here's my question. If I, as a trainer, have taught this dog to bite, then isn't it already a dangerous dog before it literally bites another person?
In my position, that's a worthy question to ask if you're in front of a jury and try to persuade them that yes, this dog is already dangerous before they bite. Statutorily, based on what's written in the laws about dangerous animals, unless they have aggressively approached without provocation or bitten or injured a person or another animal, they're not considered dangerous merely from training to be able to bite. A bite is a natural instinct of many animals, including dogs. Learning to, teaching it to appropriately weaponize the bite isn't enough, in my opinion, to cross over to making that animal dangerous per se.
So I would like,
based on the way the laws are written,
I would like to say this as a trainer. I always make the example, if I create a high performance vehicle and I'm selling it, but I have not put a brake system in this high performance vehicle, then am I liable as the creator of this high performance animal or vehicle, and I have not installed a reliable brake system? Doesn't that add to the danger of the animal and the liability attached?
Absolutely, and that would be considered incomplete training, right? It's not sufficient training at that point. Yeah. Proper training of an animal would include both the high performance and the braking system, as you put it.
Yes.
Otherwise, you are completely liable for putting a defective product out there,
Yes,
for lack of better terms.
absolutely. I agree with that 100%. But in the dog training world, a lot of times trainers will spend 80% of their time and effort perfecting the attack or the deployment and the actual bite, and less time, is certainly not equal time, on the no bite or the release of a bite. If you look at the internet, most examples are vicious, horrific bites. And usually you don't see the person being able to verbally command the dog to stop biting and return to them. That's why I teach people, don't deploy your dog unless a person can affect you from that distance with a deadly projectile. I say a gun, a bow and arrow, javelin even. They have to have the ability to lethally affect you from that distance before you should deploy your animal. Also, in most states, there's a leash law. And if your dog, just watching Judge Judy, if your dog bit someone off lead, someone or even their dog, then you're in trouble. Judge Judy is not going to be kind to you. Am I correct?
You're correct. And if we wanted to extend this conversation into this dog being considered a dangerous dog at that point, if there was a one bite or some reason to know, many jurisdictions, if not all of them, require some leash or harness and a muzzle in public.
Yes.
You have to protect the general public from the tendencies of this animal.
Absolutely. I have a rule. The pedestrian has the right of way, meaning that me as a dog owner, I have to protect the public from my dog. And let me stress this point. In most cases, a dog has had 100 bites in training. I think that constitutes a dangerous dog. That if it has been trained and has had physical bites, whether it be on equipment or not, then it's already dangerous before animal control would consider it to be a dangerous dog. That's my contention.
And that's the argument I would make in court as well. If I was representing someone who was bitten by a trained dog, I would say, well, look at this footage of this dog biting this equipment hundreds of times in the course of these 3 days to a week. And it'd be pretty easy to convince a jury that that is a dangerous dog at this point, especially if the owner then goes out and isn't properly trained themselves to understand the qualifications of this animal.
I've often made the point that bite equipment is 1,000 times more tensile strength than literal flesh of a human being. That sometimes, in my opinion, all of this bite work creates overkill. That a dog is taught to bite so hard and be so committed to this bite, but it's on equipment, the same jaw pressure and the same bite on flesh and blood would constitute overkill, in my opinion.
So a question I have for you,
yes,
are there other methods of protection other than a bite that you can train a dog to perform?
Yes, I stopped doing bite work at least 20 years ago. I piled up all my bite equipment, suits, sleeves, and I set them on fire. I was upset that a guy could get his income tax return, go buy a bunch of bite equipment, and a business card and present himself as a professional trainer. And so I called it the sacrifice made by fire, and a challenge that if you have to use this equipment to train a dog to defend, then you are not a professional. So in answer to your question, yes, I use muzzle training. So I am criticized sometimes by other trainers, sport and police training, of course, that, oh, you can't depend on a dog to deliver the devastating bite if you haven't practiced or simulated 100 physical mouth-on equipment bites. Here is my theory to defense. Defensive protocol is alarm, challenge, threat display, and then engagement. If the alarm, and this is defense, of course, I don't teach people to track down people or apprehend people. I contend that if your dog is a good protection dog, you don't have to chase anybody or apprehend anyone. If the dog is strong on alarm, challenge, and threat display, most people, bad guys, change their mind. Human beings have a genetic component in their brains that is averse to being eaten. And so this is from caveman time. So if your dog meets a person at the door or the gate, or if I'm out in public in my car or even on lead, and my dog alarms, challenges, and threatens, most people are going to relent. They're going to move on. They're going to look for a softer target. And so that's what I concentrate on, the defensive protocol. And this is a natural defensive protocol. All communal animals, pack animals, if you want, are equipped with this alarm, challenge, threat display, and then engagement if you don't heed the threat. Does that make sense to you?
Yes, it does.
Okay.
And that sounds like sound training, in my opinion.
Thank you. So the muzzle does not teach a devastating bite. When I bite it, I'm not going to let it go. And so therefore, it is easier for a dog to be told no or to refrain from biting when instructed or commanded by its owner. And that's why I use the muzzle. And also there's other reasons. One reason is in every demonstration you see they call them decoys. I hate that terminology. It's a bad guy, an agitator. But even in police demonstrations, the bad guy has a gun in his right hand, a sleeve on his left arm, and the dog always ends up on the sleeve and not the weapon. So that tells me that this dog is not interested in defending. It is compelled or has a habit of just biting, that its goal is to bite, not to defend. That's what I teach. And that's, to me, closer to the moral and legal justification. I want to move on to things like the Castle Doctrine and the stand your ground. That if you see over my shoulder here, it has house protection training and castle law, that we base our training on the castle law and of course stand your ground, which is your personal space outside of your home, on lead, also in your car, and especially in your home. Can you elaborate on that? Can you tell me if you disagree or agree? And either way, please elaborate. Go ahead.
I would agree with you. I would liken the use of a personal protection dog under the Castle Doctrine is the same as having, you know, a shotgun in the closet or, you know, some other weaponry to protect your self from bodily harm or from any crime being committed within your premises and your private property, which is a protection that we all have and can enjoy. The same with the personal protection in a vehicle and in your personal zone of personhood. A protection animal can be employed in the same way to stand your ground from a perceived threat. Like we said, the spacing matters in this point, and also when you come to defend yourself in court and say, hey, I'm standing my ground from a guy with just his fists and words from 15 feet away, is it the same as someone on me with a knife from 1 foot away or directly into me?
Yes.
There's a difference there. Of course, a projectile closes that space as well.
Yes.
The threat zone is increased at that point. But you know, stand your ground and castle doctrine are both two laws that we enjoy in this country that allow us to protect ourselves and our loved ones from immediate harm.
Yes. The other thing I would say is that I always encourage people to go through the training process themselves with their dog, and not have a dog trained outside of their presence and then just brought to them. I liken that to you receive a machine gun in the mail in pieces. You don't know how to put it together. If it jams, you don't have any background on how to clear the jam so that you can continue to use it. And so I always tell people, no, I don't want to take your dog and train it. If I do that, it's my dog. And then you don't know anything about what went into the process. So if something goes wrong, you have no background on how to fix or adjust. Does that make sense to you?
It does. Go ahead, Sean.
Yeah, I can jump in on this one. I think that's a large problem that you're seeing with the protection dog business.
Yes.
It is a business.
Mm-hmm.
And because of that, you have people that can create dogs that they're selling for $50,000. You can get a $50,000 Malinois that's fully trained, 1.5, 2-year-old dog, and they're shipping it out to the people that can afford it, which is often someone in the suburbs, a mom in the suburbs that feels she needs a protection dog. The issue you have with that on both her end for liability and the trainer's end for liability is that this lady sees a dog 24 hours a day, loving her family, being a great dog. But the dog has an on switch.
Yes.
When the dog turns on, she's never seen the dog on before.
Yes.
And that causes an inability to turn the dog off, and which causes more damage. So I think you're always setting yourself up for liability purposes as an owner and even as a trainer when you're giving people that are not qualified to handle these high level protection dogs. You know, in my opinion, I don't believe that the average person needs to have a Malinois. People love Malinois. You don't need the dog. You need a German Shepherd maybe, but you don't need a Malinois. But you have people buying Malinois and they don't know that the dog's on switch is a little bit too much for them. And that's what's leading to a lot of liability issues and bad bites.
I always tell other trainers, don't give a dog that's on 11 to a person who is a level 3 or 4. That's too much dog for them. They don't know how to handle it. And that's a recipe for disaster. I see by the clock that we're running out of time. Is there anything? First, I want to say that off switch is equal importance and weight as an on switch. And trainers need to figure that out and work accordingly. Is there anything you guys want to say in closing? And I, first of all, thank you so much for this conversation. Go ahead.
All right, thank you for your time today. This was honestly a pleasure, and I learned a lot from you two gentlemen as well. The key pieces I want to leave everyone with is that as a dog trainer, you have to be sure not to misrepresent the effectiveness of the training. That's a surefire way to be held responsible for anything that happens with that dog after it leaves your care. Just as you suggested before, have the owner there to see the entire training process and see what this dog is capable of, so they have a true understanding of what is possible once they leave your training facility. Also, do not overstate your qualifications to train a dog.
Yes.
All money is not good money. Like we said, this is a business, but you have to be discerning and make sure that you don't keep yourself in a place that is a precarious position going forward and have a bunch of bad bites coming out of the training facility.
Great. Sean, anything to conclude?
On my end, from a person, I'm going to speak more so as the owner. If you own a dog, it's important to know your dog. Not every dog needs to be a killer.
Yes.
Bluffing goes a long way.
Yes.
So if you have your dog, don't let people in your neighborhood pet your dog.
Yes.
Most dogs are going to bark when someone comes to the door. That is really enough.
Yes.
If someone comes, Gypsy gave me the best advice ever when I bought my monster, a Casseret Malacli. Keep it on the lead. Don't let the person that comes to your house touch the dog, and that's enough. If you have a big dog, any dog that's above 50 pounds is going to scare most people.
Yeah.
So protection training, I know a lot of the trainers are going to hate me for saying this. It's often not necessary. A good bluff goes a long way.
I agree.
And can save you a lot of money and headaches.
That is the defensive protocol that has worked for eons: alarm, challenge, threat display. And if those are successful, a bite is never necessary. In most cases, bad guys do not want to be discovered. They do not want to be hurt. And so if your dog is presenting itself as, I am protecting this, they move on to a house that has no dog. That is true universally. And so I would like to thank you both so much. And if you ever want to have this discussion again, please reach out to us. And if we need help, and if any of our audience needs help, hopefully they'll reach out to you guys. So thank you so much and have a great day. Stay safe.
All right. Thank you.
Good. Thank you.
Always a pleasure, Gypsy. Always a pleasure. Thanks for having me.
All right, guys. Thank you so much. Peace.
Bye.
Okay, man. We did great.
It's over.
Oh, okay. How'd it go? Wait.